We are live.
All right, welcome to the House Judiciary Committee this Friday morning, February 13th. First order of business is a vote on H 578. We're having posted right now draft number 3.1. Just by way of introduction, before Eric explains the one change that's on page 15, is the Agriculture Committee. They looked at this the last couple of days, and they had a little confusion on this one place where Eric will address, and we went back to some language that we had in a previous draft. The Government Operations Committee has looked at the one section that they needed to look at the very end of the bill. They actually did a straw poll. It was 803. Agriculture did not do a straw poll. I don't think it was really necessary. But they looked at they looked at stuff they wish they hadn't bothered looking at because it's not their jurisdiction. But they did look at the stuff I asked them to look at as well, which is related to livestock. And overall, they had some suggestions that actually, frankly, just don't fit. But actually, they were generally fine. They were fine with that provision. I'll turn it over to Eric to explain the one other thing, and if there are any questions for Eric before we vote.
Sure. Thank you. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, here to take a look with the committee at version 3.1 of the House Judiciary Committee Strike All Amendment, page 578. As the chair was mentioning, there is, other than, as the editors always do, various changes, one of which I do want to point out after we talk about this first one, because it's quite interesting.
It was where I hope.
No, I didn't even, right, good question. I didn't double check that. I think they kept it. I didn't see any changing, so I think it went to, I think it stayed with Word.
Okay.
Yes, right. But the one change that the chair mentioned is on page 15, line 15 of page 15. And you remember the committee has gone back and forth once or twice with whether or not to frame that language. And this has to do with the veterinarian accompanying the humane officer when the warrant is executed for purposes of seizing an animal that's being subjected to animal cruelty. And the language in the existing statute provided that the veterinarian must accompany the humane officer. I think the committee was trying to discuss, under what circumstances would it be required? What legal effects would it have if the person was not accompanied by a veterinarian, for example? And the committee's first attempt at how to address that situation was to, rather than say must, say shall if practicable. And then in the go around after that, committee clarified the consequences of the failure to accompany even further by adding that second sentence based on the same concept having to do with the Secretary of Agriculture being consulted. And that's making clear that, well, if the vet doesn't accompany, that doesn't mean that this enforcement action is going to be dismissed. So you add that sentence. And when that sentence got added, I think it became clear that it really made more sense just to go back to your first thought, which was shall if practical. Because then you just, those two provisions read together make sense. If practicable, the veterinarian accompanies. If not, though, it doesn't mean that the enforcement action gets dismissed. So I think that's where the landing point was as far as logically what makes sense with both changes.
And we thank Agriculture for weighing in on that. Okay. Was there any other changes you had to highlight, you said, as far as from the edit?
Well, more from from an interest point of view, and that would be over on page 10. Now, this has to do with the
Posted, folks, if you
starting on line 1, goes really line 1 through line 17 of page 10, and it has to do with Romanettes and Roman numerals. You'll see. So what the editors pointed out was that in the previous draft there were no Roman numerals. You see the Roman numerals, which we used to refer to as capital 1, capital 2, capital 3, in lines 1, 4, and 7. Those were Romanet 1, 2, 3. And line 16 was Romanet 4. But the editors pointed out that it did not make grammatical sense to have that last sentence that is now Romanet 2, to be set off the way it had been because it was in a list that was had introductory language at the very top of the page. You had a separate sentence like that, it grammatically didn't make any sense. So they said, how do you want to fix that? And I said, I have an idea. Let's put Roman numerals in for the first three, and we'll change Romanet 4 to Romanet 2. I thought it's very interesting for many people in this committee as well, considering our lengthy discussion of Romanets over the past several weeks. That was the other one I thought would be interesting to me. Not a substantive difference, but still reads better.
Something that
Somebody.
I'm happy.
Right, right.
That brings me personal joy for.
Happy to hear that.
All right, any questions for Eric?
Okay.
Anybody need more time? I'll take a motion to start by, let me make sure I'm getting my motions right. Always got to do that. There will be a straw poll motion. No, I think I need a motion. I don't need a second on straw poll. But I will take a motion anyway. I'm going to take a motion to approve amendment 3.1 to H 578.
So moved. Second.
So all those in favor of the amendment, please raise your hand. Right, and now I'll take a motion that we report H 578 favorable with amendment.
So moved. Second.
All right, any discussion? Oh, all right, so we'll start with Alicia, then Ian, then Barbara.
So I brought it up once previously, but I couldn't remember if it was I can't remember. So I just want to make sure this can't be used for frivolous claims, correct? That was my one concern, like with municipal animal control and the kind of often frivolous claims that we hear.
I would ask Eric, well, I mean, so one can't completely prevent frivolous claims.
No, not
It's
the
setting-
claims, the convict, I guess, then how much, does this put more teeth in those frivolous claims? I guess is what.
No, because I mean, well, the claims would be brought by prosecutors against individuals who are committing animal cruelty. It's not like, this isn't opening up claims against municipalities. If that's kind of part of the question, I don't see anything in here that.
Part of the question, only because that's that would be my experience, but trying to word this in a way that's like not disrespectful to maybe animal activists, but sometimes there's a broad range of what constitutes
Right.
cruelty to an animal.
Yeah, but this,
Hoping that this doesn't open that door to that.
because it's prosecutors are involved and they have to exercise their discretion on what cases to bring. This isn't bringing in new civil remedies that don't already exist.
Okay, I just wanted to, thank you.
Is that correct? Did I knew
Yes, and I would add also that the language around when an animal can be seized and subject to forfeiture, which is on line 15, isn't changed. So
Yeah.
whatever is the case currently,
Yep.
this doesn't change that one way or the other.
All right.
I don't know if that helps.
No, that does. Thank you.
Along the same line. You're talking about the frivolous cases, would the town be, in a lot of cases, be the first people that would go out to see what's going on? The animal control officer, and then
Yes.
decide if it's a frivolous case or not?
Yes.
And if it's not a frivolous case, then that animal control officer or town manager or whoever then would pass it on to the next level.
That is true.
Is that-
And there's just a lot, there just often are times there are people who will push it, when there's a lot of people that just see animals outside and are automatically, it's cruelty, it's cruelty. And then it can be stopped at the municipal level. I just don't know I didn't understand if this was, but that helps me. As I said, I didn't know if this was adding any kind of additional language that somebody could point to and be like, but see, this new,
And I ask only because I'm not familiar with
yeah,
procedures.
okay. Yeah, but no, I think that sounds like it's.
Yeah, I agree with that. Doesn't matter. It's whatever the state is now, as far as that goes, will be the same,
Okay,
for better or for worse.
yeah, okay, thank you.
Yeah.
Yeah, well, and I think I would also say, because this bill helps to expedite the civil proceeding,
Mhm.
if there was a frivolous claim, that's better. That,
Okay.
yes, you're right, like, we're moving the process forward faster, so if it's frivolous, then we're all gonna understand it's frivolous and it will be able to be sort of resolved faster than this long protracted thing, where, you know, people are having their animals taken for maybe they shouldn't have.
Okay.
So, but I think it's a really good question. I was just going to say, as one of the sponsors of this bill, that I'm very grateful for the time that the committee has taken on it. And, you know, all joking aside, this is a really important issue. We have from a lot of witnesses that the current system, when it comes to animal cruelty and animal forfeiture in Vermont, is not working as well as it could. And I think that this bill in the draft form that it is now is going to help to alleviate the pressure that animals and animal shelters are currently feeling. And so I'm just very grateful for all the time that we put into it and for Ledge Council's work on it, because I know it took a lot to get there, but I'm very happy with where it's landed and I'm happy to vote for it.
Okay, so with all the problems and issues facing us that address human suffering, I know many think we spend too much time on a bill that protects animal cruelty. Animal suffering is not only reprehensible because animals do suffer, they are not just regular property. I'm proud to vote yes for a bill that will help to protect animals, rehabilitate abusers who often have underlying issues that lead to other types of violence and harm in our society, and that will protect shelters from going under.
Anybody else? Thank you, Legislative Council. Thank you, Eric. Thank you, committee. This was the bill that took a lot of work and back and forth. I really predicted that we'd have 7 versions, so we did pretty well, and only 3.
That's 9 lives.
You know, we want that. Oh, exactly. So the clerk can call the roll, please.
Arsenal,
Yes.
Dolan,
Yes.
Goodenough,
Yes.
Holstein, yes. Harvey, absent. I'll find that later. Molly,
Yes.
Oliver,
Yeah.
Rachelson,
Yes.
Christie, absent. Burdick.
Yeah.
Long,
Yes. And I understand Barbara is free to be a reporter on this bill. Should be a fun one.
We got you. We got you.
Yeah.
We're here for you.
We got you covered. So.
I do.
Is it going to approach first?
It probably is, but it will go to the floor and then to approach.
Okay.
And I will double check that's going to go to approach, so if it's not, we'll be ready to for Wednesday, but my understanding is it's going to. But I'm gonna double check.
Get away from me
I
too.
don't think so.
Okay.
So,
And-
but you never know with them, so.
And Nate, so
don't we just
are
make the
you
motion?
you're able to email me?
Well, they just automatically send it.
It's supposed to be nice.
All right, so thank you very much, and we need to move on, Matt Valeria. And, we're looking at, a couple of different things for Matt.
Karen got it.
Bakery.
Take your cake with you, and, we'll, and let Michelle and Hillary know there's cake over here.
Oh, yeah.
It's not by.
Yeah.
You can text them or email.
Yes.
And Eric, that if you put a number on that cake, it's 1.0.
All right. Thanks, guys.
Thank you.
All right, so we'll move on. All right, thank you, Matthew. Matt, I apologize that we didn't get to you right away, but I was gonna lose a committee member and couldn't postpone that vote, because we need to get that one out of here, so I apologize for that, but I appreciate you being here. So we wanted your view, not necessarily, I guess, to start, not necessarily on the language of H579, I can't remember exactly.
Yes.
529. 529, thank you. Certainly could weigh in that, but yesterday we really talked more conceptual, what was happening with the pretrial supervision program, why it's not being used as much, and what we could change to make it a viable program. So that's so it was more kind of that background, if that's okay, but welcome to comment on that as well.
Yeah, I'm Matt Valeria, Defender General. And you want me to do 529 first?
Yeah,
I don't care which one. Doesn't
no,
matter.
I would do more conceptual, and I think it's just.
So whatever, I testified at length in House Corrections and Institutions about the pretrial services I literally was there for an hour talking with them. The programs had almost nobody in it. I mean, you could count the total number of people on less than two hands. And there's all kinds of reasons for it. And I think what I told them is that I would abandon the program. I don't think that it's not a matter of use it more, it's get rid of it. As of right now, I think you're talking about, if you add the carry forward money from a couple of years ago, there's been committed about $1.5 million, and we've dealt with 8 people in the program, and not all that hasn't all been spent. But the bottom line is, I think it was ill-conceived given the structure of the way we have things in Vermont. When Senator Sears brought this issue to the fore, it was because he saw Illinois had done something like this with a pretrial services program, and that the feds have a pretrial services program. And these were places where the probation and parole is actually under the jurisdiction of the courts. It's not under the jurisdiction of the Department of Corrections. So, and you're in areas where you have, sufficient social work and mental health and substance abuse resources to access for people who might be in it. The concept is not wrong. The way we did it is totally wrong. And so I don't see it working at all in the way that it is currently conceived. What I am convinced does work is what we just did in Burlington, which is having the availability of social workers from my office, resources from AHS, and the Department of Corrections available for clients who present like the ones who would be affected by 529, that group, available at courthouses, so that for those who want to take a treatment route in the resolution of their cases, all of those resources are ready. The court can make conditions of release that apply to the situation. There are AHS screeners available. My office would have a social worker, which I don't know if you folks were all at the last thing that I talked about, so that we could do our own, trust but verify kind of thing with the screenings, and also with the making sure that once releases are signed and the person's amenable to doing it, we can make sure they get there. And that worked. Now, it's not going to be easy in every county, because for all of the reasons I talked about the other day, sometimes you don't have the treatment resources, sometimes you don't have maybe I'm not going to be able to find somebody who can social work that county, and I'd have to bring somebody in from somewhere else. Whether we're doing it by contract or, I think contractors is the way to do it with the social workers, honestly, because that can apply to both my conflict side of the program and the staff side of the program. But the bottom line is, the way our system is set up is not amenable to implementing what was passed a couple of years ago. And that's why one of the biggest reasons why we don't have anybody in it.
Is it also in part because of the kind of narrow restrictions we put in there as far as 5 dockets, violation of conditions of violence?
There are plenty of 5 dockets with violations of conditions. there would be plenty of people who fit the criteria. But you got to remember, you're dealing with people pre-conviction. So you can't order them around the same way you order around somebody who's on probation or, you know, on furlough or parole or whatever. So, you know, what this always presumes is that everybody who's charged is guilty and we want to get you into treatment. Well, that isn't true. Some are actually innocent. Some would be not guilty because the facts don't support the charges. And there are all kinds of reasons cases go away that have nothing to do with treatment. So you get, while you're going to have a bunch that are amenable to it, there's also going to be a bunch who are going to be want to enforce due process rights. And you know, there's sort of another side of this too, which you know, we're defenders in general, and I'm not just public defense, but any defense lawyer is representing the not just the rights but the wishes of the client, and so that oftentimes interferes with, you know, amenability. You know, one of the things I don't, sometimes folks from administration have said, well, you know, the lawyers are an impediment to us having clients access this stuff. What it is actually the clients are the impediment to the clients, because we are actually representing clients. We don't settle cases. Clients ultimately decide whether they're going to settle cases. And so, you know, there are times when you go, well, why isn't this case in, you know, in treatment court, or why isn't this case in pretrial supervision or in some other, you know, I've had clients turn down diversion referrals because they're like, I didn't do it. I'm not going to admit anything. Why the hell would I do that? And, you know, even if I only have to write a letter saying, I'm sorry, I did something I didn't do, and then I could walk away. And there's plenty who do that too. So the bottom line is that I don't think that, I think part of what we've learned from this is that well, if you open it up, I don't know that you're going to get much different result. But I wasn't totally surprised, as I said a couple of days ago, but I was I was happy that it kind of reinforced something that I thought all along, is that if we, you know, focused resources on a particular docket, you'd get a particular result, which we did. So there are really two things going on at the same time. You know, it might not have been the best thing in the world to start it in Orleans County, where you know, and then it sort of got transferred over to Chittenden County at the same time we were doing the multi-docket court, the so-called 3B court. And so that was drawing a bunch of people who would have otherwise maybe done this, but I'm not sure. You know, the thing about this is this sets up a totally adversarial situation with the client. So, you know, you sign up, I'll do these things, but then you have the prospect of being violated for the things you agreed to do that you might not be able to do. And I always saw tension with signing up for something that might get you in more trouble. So anyway, conceptually, that's what I see.
So a couple questions on that. So, I mean, if we lifted those restrictions, and if it was more of the situations where somebody has been a flight risk, you know, there's a good case that they are a flight risk and that bail could be imposed, but the choice then is, all right, we're going to impose bail or have you under pretrial supervision. I mean, might that change people's, you know, defendants' calculus on whether to?
I think that's basically what it is now. I mean, the only people who have done it, I actually talked to Vince Luzzi just the other day. He says, I got my first one on pretrial supervision. I'm like, geez, Vince, how'd that happen? He said, well, he had a choice. He was either going to go to jail or be on pretrial supervision. I'm like, that makes some sense. But you have to get to a certain point, because our constitutional bail laws, you know, you're a few problems down the road before you get to the point where you're required to, where it gets to the point where you're going to be held on bail or without, or you're going to go on pretrial supervision. The thing about this too is, remember we had the home detention that was out there for a while, and there weren't a lot of people on it. It's the exact same thing.
Right.
It's basically a last resort. Said, look, we're either going to put you. I was almost getting very colloquial there for a second, but we're going to put you in jail, or you're going to have home detention so you can go to work and go to the doctor, and otherwise you're staying home. And there's your choice. Well, there weren't very many people on that, like, statewide, less than 10. It's the same thing. It's just, we aren't necessarily confining to their home, but we're asking them to do certain things, because the way the law is, you have to put the least restrictive conditions to ensure that somebody is going to show up in court. Not that somebody is going to do things, but show up in court. So we said, if you get to that point where there are no conditions that would ensure you coming to court, we're now going to impose bail, or we can do pretrial supervision, which is kind of like your last shot before that. So you're whittling the population, whether you say you need 5 dockets or no dockets, or or 1 docket. It doesn't really matter.
So something like home detention, a client is given an either or choice. It's just not something that's implemented by the courts.
With home detention, there are 2 ways that it can be agreed to by the state's attorney and the defender, or one of the ways it was originally constructed, you end up being held on bail, and if you're not bailed out within 7 days, then Department of Corrections has to file something with the court that says this person is amenable to home detention. Basically, they have to have a good place to live that is that corrections approves of, which that wasn't always easy.
That's connectivity.
Huh?
Connectivity,
Right, connectivity was a big issue.
that they can connect to the,
Their
to
bank.
cell or whatever.
Oh, yeah, they had to have a phone, so right.
Are you good?
Yeah.
Angela, Mary.
But you can't be couch surfing. And we have a lot of clients like that who they're either, considered homeless, or they are transient. A lot of transient, just moving friend to friend, place to place, phone to phone.
Yeah.
That kind of thing.
So two questions. I caught myself yesterday using pretrial supervision and pretrial services interchangeably, and they're different, right? Would you say they're different?
I don't know. They're kind of the same. I don't know what you're trying to say.
Well, because you said that, pretrial supervision, rather than trying to tinker with the program, we should just scrap it. And that's not to say that we should stop offering pretrial services to.
Right. Well, what we're doing with the 3B court was really connecting people with the services. That's not the bad thing.
Right.
It's just that when you formalize it and you basically put someone in a position where they sign up for a situation that could get them violated and incarcerated anyway, why would you ever do that unless it's like your very last resort?
Right. So that's my second question is in the 3B docket, how were things framed for your clients? Like, what was the framing? What was it?
Really what they wanted to do is get them to court. So they got them to court, and they said, now that we're at court, let's say compare a traditional due process model to what was going on there. You'd be brought into court, and we'd apply the bail laws, and the judge would, if you were qualified to be held on bail, the judge would impose it, or would impose conditions of release, and they'd set another court date. The difference is with the 3B docket is that we had needs screeners at the courthouse. We had Department of Corrections at the courthouse. So those cases that could be resolved, you had people right there who were telling you like what we could do if we were going to do a furlough sentence or if we were going to do a probationary sentence and the like. And you also had, because our clients, believe it or not, don't trust the Department of Corrections or the state or law enforcement. We had our lawyer there, obviously designated specifically, and a licensed therapist who could confirm or say, hey, that screening's BS. And we could say to the client, yes, we reviewed it, the screening is legitimate, and we will make sure that you can get where you need to get to access the services you need to access. And so you had all of these resources readily available on site every day to get those people where they needed to go and at least get them started. Now, as far as clearing a docket, it did a great job.
Mhm.
Is it going to prevent recidivism and all of those things? I don't know. It's been 2 months, and it also depends on what your definition of recidivism is.
Yes, no.
If you do a 6-month recidivism study, we're probably going to be great. If you do 5 years, it's probably going to stink like it always does. But somewhere in the middle there.
So then it sounds like the supervision provided in the 3B example or.
Well, it's the services provided.
Right, but there.
Because they can
there's a
choose.
level of- So I guess that's what I'm trying to
The
understand.
defendant
this.
can choose. They can say, I'm not doing any screening. I want a trial. And there were a good number of people who said, okay, and they'd say, fine. Now you're going down the hall into the regular due process docket, and we'll forget about this stuff. And along the way, we'll, as part of your lawyer dealing with the case, we'll bring it up again and see if But there are some folks who said, I want to try it. And so but you had a good number of folks who took advantage of it. There were hundreds of dockets that were resolved.
Right, and so those folks who opted in.
Yeah.
Were supported in their acquisition of pretrial services,
Yes.
not supervised.
Right. Yeah, I don't think they were really supervised per se.
Okay.
And that's kind of the difference.
Support was key, I'm sure.
Oh, absolutely. This is, Chittenden County has done this before. When TJ was up there, Andy Polito was the corrections commissioner, and myself, Andy Polito, and TJ signed on to, we approached Senator Leahy about getting a grant for what was then known as the WIC program, if you remember. And all that was wraparound services for people before they were ever charged at that point. And there was a coordinator, and TJ stole somebody from my office to do the kind of the legal side of it for the state's attorney's office. But it was the same thing. It wasn't just mental health. It wasn't just substance abuse or co-occurring. It was housing. It was employment. It was transportation. It was childcare. It was you might not have any problems with mental health that need specific addressing. I think we probably all have some problems, and or any problems with substance, but you have no transportation, and you got 2 kids, and you don't have a place to live on a regular basis, and all of those things are going to impede your ability to be successful and even show up at court. So what the RIC program did, but it was all pre-charge, was get a whole bunch of people out of the system. Now, eventually the grant went away, and then the program went away, as things tend to do. But what we did, and what the governor committed resources to, and brought us all together to do, and I honestly, without him pushing it, I don't know that it ever would have happened, because we needed to get those resources. I found it within my own budget, but it was DOC and AHS and the Howard Center and all of those folks. This wouldn't have happened to get them all together at the table. we're just doing the same concept as what Rick did 20 years ago.
And Sarah George had a similar initiative that she used grant funding for a couple of years ago. And it's, so yeah, whenever it's grant funded, it ends, it falls apart. And then we think we're learning some new revelatory lesson. That why do we have to keep learning the lesson? Why don't we
You know,
fund what we see works?
yeah, I will say the big thing here, and I know that it's passé maybe at this point to say this was all caused by the pandemic. But honestly, this was all caused by the pandemic. I mean, the things that you guys were arguing about yesterday while I was watching you argue about it was
Conversing.
caused, I don't know. I saw one guy seemed like he was arguing. Anyway, in any event, when the court takes 2 years off, and the only things you can do, because constitutionally you absolutely have to, are the held without bails, the speedy trial cases, and the juvenile cases. Every other case is getting pushed to the side, every single other one. I mean, I'm sure the public doesn't like, murders on the street and that kind of thing. I get that. But the thing that really annoys them is all of the other stuff. It's the people in their doorwells, of their businesses, and the people coming in to get warm, and the people taking stuff. It's all in the general scheme of the criminal justice
What do
system.
you mean by people taking stuff, stealing?
Yeah, retail theft. All of that in the general scheme of the criminal justice system is relatively low on the level of when you're trying to, what the court prioritizes, what the Constitution prioritizes. The problem is all of those cases were getting backlogged. Those are the ones that nobody was dealing with. And while they weren't being dealt with, more of them were occurring, and more cases were being brought, and they were violation of conditions. But when you're in a backlog, you are still have to deal with those core fundamental, the speedy trial cases, the murder cases, and the juvenile cases by statute get priority. So the other ones were not. There's no surprise at all that you were going to get a backlog of those quote unquote minor cases. But those minor cases piss everybody off. That's what, on a day-to-day basis, that is what annoys people. So you've got to get rid of them.
Yeah.
And this is, with the resolution of these cases, I saw Sarah George the other day, and she's like, what we did in like this 3 months with this intensive effort has kind of made manageable everything else that we were struggling with in the office. There, the caseload per attorney like shrunk immensely. And the ones we were spending all this time on that built up, when you can't deal with them for 2 years, I always say it's going to take way more than 2 years because the new ones keep coming in. Something had to happen. In Franklin County, state's attorney and the defenders got together, and at some point they got rid of hundreds of cases like voluntarily. They just said, I mean, they didn't actually do a Rule 48, but they did stipulate to dismiss them. But it's akin to the same thing. Yeah. And so, we're just in a situation where we are still, and it's 2026, and the pandemic allegedly ended in 2022. It was declared ended, and it ended then, more or less. But we still are dealing with that 2 years of minor cases that are just lingering out there.
And so I want to get back to talking about DOC and the pretrial supervision. That was helpful, but with the limited time we have. So looking forward, I understand that pretrial supervision program has not been bringing a lot of people in. That one of the things that we were going to at least open it up a little bit to more discretion of who might go there, and it's still going to be narrow. But at the same time, we want we would like to see in the different courts that are doing something like we did in the 3B docket, like every Friday or whatever they're going to do, that they have a DOC liaison essentially there to try to recreate how that happened. It's possible that that DOC liaison in those situations could also handle the supervisory duties, of the pretrial supervision of the handful probably of people that fit that program. So I think that's kind of where we're heading, but we want to make sure that the pretrial supervision can be as useful as it can. And I understand it's pretty significantly limited, just like the home monitoring.
Yeah.
But I mean, is there anything else that is preventing pretrial supervision from being a useful program?
Well, no, I mean, the first thing is our system is not structured in a way that would make it amenable to do. The second is that the way our Constitution is written, there's going to be a very limited number of people who would qualify for it anyway.
Is there any information issues as far as the fact that it would require defendants to provide additional information, like for the risk assessment? Has that been a barrier as well, or?
I don't think it ever gets to that point.
Would it be a barrier if it got to that point?
I don't think that's the biggest issue. Literally, there've been like 8 people in the entire state who have ever done this. There were 10 or 12 or something who sort of qualified in the pilot. And I think that the number that I had was 4 people, but I can't remember his first name, Mr. Marvel from the Department of Corrections, who was the one who was supervising the program. And I mean, you can literally look at every single individual. You don't have this isn't like a statistically difficult thing. It's more like talk to the 8 people. I don't think that was I don't think that was a huge issue.
Yeah, and it's, I mean, part of the issue that at least in the Chittenden doc and pilot was that things are moving quickly enough that pretrial supervision probably made even less sense there. So, I feel that it hasn't been given necessarily a fair chance.
It's been 2 years, right?
Yeah, but starting at Orleans and Essex, I think it was, and then in Chittenden only with respect to the pilot docket.
Yeah, I think I'm not even sure if there might have been 1 out of Chittenden.
It was 3.
I'll give you 3. How about that?
I
think so.
All right, well,
Just real quick. You're talking about the minor cases earlier, and that those are the ones that people are concerned
They're
with.
relatively minor in the criminal.
Well, right.
They're not sexual assaults. They're not.
My take on that, it's the reason it bothers people is because it's like a death from 1,000 cuts. They're like mosquitoes compared to a bee sting type thing. So, and they're always in front of people where the bigger cases, say the murders, I mean, they're there, boom, and gone and into court.
I'm not lessening at all the way people feel about it. I know exactly the way they feel about it.
But I think that's why people continue to bring up the issue.
They should.
So is a tool like this, isn't it potentially in the best interest of the client? Especially
Lots of
those that
things
are potentially, I'm not saying it's working perfect by any means, or it's written perfect in the law, but especially the ones that are difficult to keep track of, the potential.
It's always potential.
So if there's potential, how do we fix it? Other than just.
Well, the part of what you have to look at is the cost benefit analysis. There's like $1.5 million that has been committed, and we've dealt with something less than 10 people.
Right, well, that's what I'm saying is how do we fix it to get more people into it?
How about you do something else instead of, I'm not saying that it does, this reminds, you're arguing, what you're talking about is the same thing as.
No, I'm not arguing.
No, well, come on.
I'm not arguing. I'm asking questions that I don't know the answers to.
Well, I'll
And I
tell
mean, if you're gonna, you already accused Kenny of arguing, now you're accusing
Well, I
me of
watched, I
arguing.
can see.
Matt, they're just questions.
All right.
I don't want to argue with you.
All right.
Now I'm arguing with you because you accused me of arguing.
Well, then I think I won. Here's the bottom line, right?
That was inappropriate.
Can you do this? And does this help some people? All I was going to do is make an analogy to work crew, right? Work crew helps some number of people. Defenders really like work crew because it is another tool in the toolbox, so to speak,
We love it.
to assist people. Department of Corrections does not like work crew because it costs a lot of money. It doesn't show a lot of success. And so over a period of time, their cost benefit analysis is that it doesn't work. What I see here is kind of a similar analogy. Can it help some people? Absolutely agree that it can. Could more people do it? Maybe. But the way our system's structured, it's always going to be a small number. So all I'm suggesting to you is that is at a cost benefit analysis, this, to me, there are better ways to kind of skin this cat and get at this population. All due respect to me.
We just passed.
You know what I'm saying?
Oh, yeah, I understand.
It's just, can it help some people? Absolutely. Could it help a few more people?
I don't think you understood what I said is I understand what you're saying that as far as the cost analysis goes. What's the language to get more people into it?
You could just make everybody eligible, but have no restrictions.
That's what, we're gonna have no restrictions, but it'll be the discretion of them.
But I think that you're going to get the same situation, you know, because of the way bail and conditions of release constitutionally work. This is going to be, no matter if you say everybody is eligible for pretrial supervision, it is going to be a last resort after all of the other options have kind of been whittled away, and that is necessarily a small number of people. That's all. So you could let everybody in. I wouldn't even be against it. But I think you're going to run into the same thing.
So it would still be a small number of people, but would it, compared to what it is now, would it be a bigger number of people?
Yeah, but I'm guessing, you know, first of all, we were in a tiny county and all that stuff.
Yeah.
But if you look at it as akin to like home detention, which I thought was going to be a lot more robust over a period of time, they never had more than 20 people on that at any given time. So even if you said statewide, this is available and you get 50 people, it's just not much. Yeah.
Well, what I'm having a hard time understanding, I guess, in a world with limited resources, you know, I am trying to do that cost benefit analysis, and I guess I'm not very clear on, this might be for like discussion or maybe DOC to answer, but like I don't quite understand what the resources are that are needed that are not currently in place to widen the scope of pretrial supervision.
Yeah.
And if the money that we would need to put into that could actually be better spent broadening the, 3B docket type response.
Mhm. You know, DOC, Mr. Marvel, and he had another person with him. They also had a budget person over at House Corrections Institution a day or so ago. Could give you the exact numbers, but basically what I think they're trying to do is add one person in each DOC district office who would be in charge of supervising pretrial supervision. So it's like, I think it's like 7 employees. You know, if I had their numbers, I could do it. But the bottom line is it doesn't matter. They're adding some personnel to do that.
And what I'm hoping is if they are adding those personnel, that they can have a dual purpose and they can be the individuals who are the liaison, like we had with the pilot project. And secondary can be doing the supervision because they're not gonna have a lot of people to supervise. I mean, that's a conversation for DOC and Trevor Squirrel and other folks, but I mean,
Yeah,
or maybe all those resources aren't necessary. Maybe they have enough people to do both in each of the districts. I say,
you know, the key with what I saw the biggest difference really with any of this is just that they were available at the courthouse when the people were there. That is the linchpin. Now, I don't know if one in each district works. It depends how many days you do it, what courts and that kind of thing. Chittenden County had enough, gravity, so to speak, enough cases where you could have somebody there every single day, and you would have enough cases every single day. That's not going to be the case in Orange County. It's not going to be the case in Addison. I'm not sure it would be in any other county, but there are going to be some, the bigger ones. The bottom four, State, Windsor, Rutland, Windsor, Bennington, you're going to have a fair amount of volume. But I don't know how they would allocate their personnel. I might, I have enough problem figuring out my own personnel.
yeah, no, we're gonna let them, but I think the idea is to try to get them to have this as a dual purpose for individuals. But Ian, go ahead.
Just really quick question, because I'm just trying to understand your point. So you sort of see, it makes sense to me too, like the inflection point here is like the moment where conditions of release aren't sufficient, and now we're looking for bail, and this could be a release valve for somebody to get something in between the two. And so, like, you think that that's like only probably 50 cases in the state if we were to open it up to anybody, there was no 5 dockets or multiple violation requirements for this?
Well, it's bail and having not the ability to make bail.
Yeah.
So, I mean, the way the law is that it's not legal to impose a bail that somebody can't meet. The judge has to make a finding that the person actually can, that the amount is reasonable and so this might be available on some of the other ones where you have repeated violations and there are no conditions that are available that would ensure the person's attendance. So it's not even, it's almost like in hold without cases. It's almost a little higher than just like your standard, it's going to be $200 bail.
Well, because the example I'm thinking of, and it does come up enough that that's why I'm kind of curious about the numbers, is like the argument where it's 9 failures to appear. Defense attorney says, Your Honor, it's a $200 bail cap. Your Honor, $200 is going to be hold cap, essentially. My client cannot pay $200. We're at that tension moment. This seems like, right? I don't know. Is that 50 cases in the state?
Don't know.
Yeah.
We have, I don't know what our today is, which usually when we have our highest detention population lately, it's usually tends to be like on a Monday, and they're talking about 620.
Yeah.
We used to be in the range of 300, 280, 300 in that range. There are people getting held now that weren't getting held before. So it's somewhere between that 300 and then you got to get by that Monday. So what is our average? Say our average is 400. That number is somewhere between that 300 and 400. So it's anywhere, I'm guessing 50 to 100.
Yeah, no, and I'm not really pushing.
I'm just trying to think through what
yeah.
numbers you might be looking at.
Yeah.
Because I think you can exclude a bunch, and then you're probably talking some number under 100 is going to be the number statewide that might be eligible for this.
Totally.
So I'm not gonna have you weigh in on the other bill, 741, because we're going to be working on that a little bit more. So
That's fine.
Yeah, not gonna need you to weigh in on that since it's a work in progress though. I appreciate it. I don't know if we'll have you in next week. Maybe we're gonna save you some time next week. Unless you want to weigh in on S208 or S209, which I don't think you do.
We don't have.
Yeah.
them.
Yeah, we don't have those yet.
I would not know. Oh, S 208.
Yeah, that's.
Oh, yeah, I didn't see him.
I don't think,
Nothing up there.
I don't think you testified in the Senate.
No, you would have remembered.
Yeah, yeah.
What were those?
One is masking of law
Oh,
enforcement,
Jesus.
and the other is sensitive places where one can't make a civil arrest. Also not really in your realm. All right, well.
I don't
so-
think your office will qualify to defend the people that need to be defended in those cases.
You know, it's interesting. I don't know if you know this, but by statute, and I think it was something that was actually collected in bargained at some point. If you're a member of the state police and you are charged with a crime, you automatically get a public defender irrespective of means. And interestingly enough, by statute, you get to choose which public defender it is. They almost never choose the public defender, which is really, you know, they should sometimes.
Yeah.
But they often.
I would come to you and ask you to contract the best lawyer in the state.
Yeah, well, they have to be under contract already. But so, but you know, honestly, the best, and the best lawyers in the state, best criminal defense lawyers in the state are under contract with the Attorney General's office right now. They really are.
You gonna name that for us?
I'm not under contract. I'm a bureaucrat.
All right, well, thank you very much for your, thank you very much for your testimony, and
I used to be a lawyer.
we're gonna adjourn until 1 o'clock, and we'll be hearing the Department of State's attorneys and sheriff's budget presentation, which I think is the last budget presentation we need to have